Good afternoon. Welcome and thank you for joining us for the December session of our Community Associations Building Blocks webinar series. This session will cover the topic of land use and zoning. I'm Jen Ritter-Smasick, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Today's speakers also happy to take questions. If you have a question, please type it in the Q&A box and it will be addressed at the conclusion of the presentation. Let's get started with our speaker introduction. Today's speaker is Clint Hogbern. Clint represents clients facing a wide range of challenges in the areas of litigation, community associations, and zoning and land use. He devotes a portion of his practice to helping clients navigate zoning and land use issues, such as subdivision of property, zoning and rezoning matters, special use permits, conditional use permits, variances, appeals of the interpretation of zoning ordinances, certificates of appropriateness, development approvals, and development agreements. I'll turn the mic over to Clint and we can begin.
Thank you, Jen, and thank you to everybody who took time out of their day today to join us for this presentation. We know that there's a lot going on, especially as the holidays approach. So I appreciate you being here, and my hope is that you'll get a lot of good information out of this presentation and the materials here as we move forward. And as Jen said, my name is Clint Hogbern. I am a land use attorney based out of the firm's Asheville office. I do a little bit of litigation and then a lot of land use work. And my practice, although I'm based in the Asheville office, spans really the state. And I've represented clients down on the coast in the Triangle and Piedmont, and obviously up here in the mountains. And it's one of the things that I'm very proud of, is to have a statewide practice where I'm able to help clients navigate and negotiate those land use issues and questions that they may have. And so before we get started, just to kind of summarize what this presentation will cover, it's really kind of about the building blocks and the ABCs of land use law and land use regulation and things that associations may come in contact with, on a, and it may not be a weekly basis, but may come into contact with over the course of the year, and giving an association the tools in its toolbox to be able to address those issues, spot them, and then determine whether or not they can handle them on their own or work with the appropriate staff to navigate those issues, or if the association needs to hire legal counsel to help them navigate those issues. So it's really about providing that foundation to the association and the association's members so that they can best handle those issues, identify those issues, and then be able to determine how best to attack those issues or negotiate those issues. And so before we dive in really to the land use portion of this presentation, to provide a foundation for what we're going to get into on the land use side, we thought it would be best to cover some of the governing documents. And we know that this will be a refresher for a lot of you here. But as the slide sets forth, the first governing document that we want to touch on is the Declaration, which obviously creates the obligations for the association and all present and future owners and members of the association. There can then be a supplemental declaration added on to that, which may expand the community association or create new obligations, restrictions, or easements within the association. And then finally, you have the Articles of Incorporation, which really bring the association into being. They establish the association as a nonprofit corporation, and then also establish the Articles of Incorporation also establish the members' ability to vote. On the next slide, we touch on the bylaws, which govern really the association's internal affairs. What we're talking about there are voting in elections, how meetings are to be run and how meetings are to be conducted, officers of the association, committees that are responsible for discrete objectives for the association, and then the corporate powers of the association. We then look at the design guidelines, and the design guidelines are dovetail actually really nicely with land use regulation, because municipalities have what are called development standards, which guide and really force certain design standards on developers, such as setbacks from adjacent property lines, buffer yards, and buffer ring, height restrictions, how a facade has to look, or design elements within a facade. And that pairs very nicely, or is a good analog to the design guidelines that an association will have, which establishes the standards for structures, home sites, landscaping, and other items within the association. A lot of those things that are found within design guidelines are the same types of things you will find in design standards in a UDO or an LDO that a city, town, or county will have. The next group of governing documents are the restrictions and rules which govern use of the property and activity or conduct within the association. And then they can also sometimes govern member use of a lot or of a unit. And then the final governing document we have is our board resolutions, which really govern or establish the procedures for internal governance and regulate operational aspects of the association. And so now looking at the purpose of the association, if we'll go to a couple slides after this. And so, yeah, there we have the design guidelines again and the bylaws. And then I think if we go,
I'm going to unshare and get this fixed real quick, and I'll pop it right back up. Okay.
Perfect. Yeah, so what we're going to touch on the next slide for everybody, so we can keep it moving and obviously be respectful of everybody's time, is the purpose of the association. We just ran through the governing documents, which form really the basis and the contours of the association, the responsibilities of the association, and then kind of taking those all together. The purpose of the association is to manage, maintain, repair, and replace the common area elements within the association, and be responsible for actions taken within those common elements, and then to follow the governing documents, what those governing documents state, and the responsibilities and obligations set forth in those governing documents, specifically, and probably most importantly, the declaration and the bylaws. Those will cover a lot of the conduct or the operational requirements of the association. And so that gets us to, and we'll have a slide on this that you can look at and reference in the materials, is really the interplay between community associations and land use regulation. And as I said, it may not be something that an association runs into on a weekly basis or even a monthly basis, but I think it's something that an association will run into and at least have questions or a potential matter on a yearly basis. And it's something that can impact both the association itself and then also property owners, association members. And so again, the purpose of this is to give you really the basics, the building blocks, the ABCs of land use regulation, so that the association and its members can navigate those problems, really issue spot those problems, and then be able to direct those issues either to planning staff, which can oftentimes help in these issues. Looks like we're still having some technical difficulties.
Sorry about that, Clint. I'm not quite sure what's happening. I will progress to the next slide. I'm going to keep working on it while you keep going, and I will get it as quick as possible.
Yeah, I appreciate it, Jen. And so, yeah, and so that's the purpose of this, is to give you the tools to issue spot it, and then, like I said, either direct it to planning staff, or alternatively, if you need legal counsel, to be able to direct that to legal counsel so that they can perform due diligence and then represent the association or a member within the association to address those issues. the two categories that we're going to focus on here, we put them into two buckets or two issue buckets. The first being internal issues, which, as you might expect, are issues within the association. So if there is a new development or new build within the association, how those land use regulations impact that new build, when a possible violation has occurred within the association by a member, or if there's concern about a possible violation of applicable ordinances. Those are the internal issues that an association may face. I will say that internal issues are less likely to come up, or will come up infrequently compared to the external issues, which are when an adjacent development comes about, or a nearby development comes about, obviously close by to an association. What can an association do to, one, gather information about that development, to understand what that development could be from size, scope, use, et cetera. And then three, to the extent the association or its members have issues with that development, how does the association go about either trying to obtain concessions from the developer, or two, how does the association best go about to oppose a development that may not be in the best interests of the community? So those are the two buckets of issues we'll cover here in detail. We first want to start with a kind of a 30,000 foot approach to land use issues. And one of the things that we want to make crystal clear in this presentation is that the association really does need to defer to the municipality here. We obviously went through the governing documents, and in those instances where there are issues pertaining to the governing documents, the association obviously takes a front seat and is very aggressive in enforcing bylaws, rules and regulations, portions of the declaration, and what have you. Here, the association should not be aggressive in seeking to really enforce the land use regulations. I want to be careful when I say that to not make it sound like the association should blow off those regulations or dismiss those regulations. To the contrary, it's in the association's best interest to have a good working knowledge of those regulations and be able to spot potential violations of those regulations. But they should take a back seat to the municipality and its enforcement regime in working with the municipality to uphold those regulations. The only exception to kind of that standard or that rule is where the association is implicated by a potential violation, or is at risk related to a potential violation. In that instance, I think the association does need to be more aggressive and likely seek out legal counsel to best address that issue. But like I said, really what the association needs to do as it relates to land use regulation is work with the municipality, work with staff to ensure compliance compliance with all those regulations, be in contact with staff, have a good working relationship with staff. But the association in this instance is not, judge, jury, and executioner as compared to enforcing those governing documents we covered earlier. And so now we'll get to kind of coming down from the 30,000 foot view, we'll get to what I have called kind of the ABCs of land use regulation, which again, we want to give you a very solid foundation to deal with land use issues. Step one, and I know this is going to sound incredibly basic, it's going to sound incredibly fundamental, and you're probably going to ask, Clint, why are we covering this? But step one is figuring out what jurisdiction you're in, which law applies to the association or to members of the association, which again, I know sounds very basic and is one of those things that seems incredibly easy to determine, but I can't tell you how often I've had a client come to me with a land use question, and in the due diligence phase, I've asked, are you located within the city or the county? Where's the property located? And they very confidently was like, Clint, I'm in the city or I'm in the town. And then I go and perform due diligence, and no, actually, you're in the unincorporated. You're in the unincorporated portion of the county, and that is fundamental, and that guides kind of the next steps. So this is 100% step one, is determining which law applies to you. Are you in the unincorporated parts of the county, and do the county regulations apply? Or are you in the corporate limits of a city or a town? And do those regulations apply? Because you have to know where to look to understand, what the scope of the laws are, what the regulations are, what the use restrictions are, what the development standards are. So that is critical. And then at the bottom, you'll see we have what is called Extraterritorial Jurisdiction, or ETJ, which is kind of a subset jurisdiction where, for property that is located in close proximity to the corporate limits of a city or a town, but is technically located within the unincorporated portions of the county, an association or property within those kind of in that close proximity may be located within what is called the Extraterritorial Jurisdiction, or ETJ. And for policy reasons, state law allows for towns and cities to exert land use control over those portions within a close proximity. It's typically within about either a half a mile or a mile of the corporate limits. And they do so kind of with the eye towards those lands coming into that city or town at some point, being annexed into the city or town, and not wanting it to be totally different or completely different in terms of a land use regime when it is ultimately annexed into the city or town. So if you have an association that is technically within the unincorporated county, but located next to or nearby a city or a town, it is worth checking out to see if you may be subject, even though you're in the county, to the land use regulations of that specific municipality. Step two, after we figured out whether or not we're in the city or county or ETJ, is to look at that law. And so it is looking up. All of this is publicly available online, easily searchable. You can find it by going to Googling your jurisdiction's planning department. It should be readily accessible there on the website. And when you pull that up, what you're going to see are a couple of kind of key terms or phrases. The first two kind of work hand in hand, which are Uniform Development Ordinance and then Land Development Ordinance, UDO and LDO. Those are one and the same thing. It's just some municipalities will call it the UDO, others will call it the LDO. Those are the core documents. That's the core document that sets forward the regulations. So it sets forward use restrictions, permitted uses, development standards, parking regulation, signage, height restriction, setbacks, buffering. All of that will be contained within the UDO and LDO, and it governs the zoning and the land use for those municipalities. The second document, which is the third bullet point here, is the comprehensive plan, and the comprehensive plan or comp plan, which you'll hear referred to as a prospective looking document that takes a kind of a future look into land use for that jurisdiction and for the municipality, and really tries to set out what types of uses they want to see grouped in certain areas, how they want the municipality to develop, and the trends in development for that municipality. It's a prospective looking document. It's not a per se binding document, but it is something that is looked at by staff for certain requests, and when assessing the viability of certain requests. And oftentimes those requests will need to be consistent with the comprehensive plan. And then finally, we have the zoning map, which is also readily available online, which just gives you an idea of what the current zoning of a parcel or parcels are. You can go in and you can see what the zoning of the association parcels are, what the zoning is for adjacent parcels to the association. And so that gives you the most immediate snapshot of what the zoning is. And then you can go and take that information acquired from the zoning map and go into the UDO and LDO and see, okay, what are the implications of that specific zoning district? What are the development standards? What are the use restrictions? And so it's taking the information from the zoning map and applying it to the UDO and LDO, where you really get the substance from a land use perspective. The next kind of core component here is understanding the players. I call them the land use starting line up here, but it's the people to know, and it's the people that you either need to develop a relationship with or just understand kind of what they do, what their function is. And really the key and most important relationship that you can have from a land use perspective is with planning and development staff. Each of the municipalities, whether it's a city, a town, or a county, will have a dedicated planning and development department. And within that, they'll have a number of staff members that are headed up by a planning director. And really, I encourage each association to have some type of relationship with a member of that staff so that you know who to go to if you have a question. Staff is incredibly helpful. Staff is incredibly knowledgeable, and they are there to assist members of the community who have questions about the UDO, who have questions about the comp plan, who have questions about zoning, and who have questions about prospective development nearby or adjacent to an association that may potentially impact that association. So I think it is very much worthwhile for an association to develop a relationship with a member of staff. And it doesn't need to be constant communication, but I think having somebody there that you're comfortable going to can help you, because while legal counsel is great, and I'm happy to help any and every association navigate land use issues, each jurisdiction is different. I mean, there is some uniformity between jurisdictions, but jurisdictions and the UDO and LDO will have some variability compared to planning and development staff who is just working in the same UDO and LDO day to day and knows it backwards and forwards. So I think having that relationship can, one, be very beneficial to the association from an efficiency standpoint and from a cost standpoint. Yeah, somebody who you can go to with those issues. The next three bullets here are the various boards and commissions that handle or deal with or hear land use related cases. The first is the planning board, or it can also be called the zoning commission or the planning and zoning commission. You may see any of those three. And that's typically a board. It's an appointed board. It's a volunteer board. And what they do is they typically take a first look at cases. There are some instances where they will be the final arbiter of specific land use cases, but typically the planning board or a zoning commission will be the first look at a case and then provide a recommendation either to the Board of Adjustment or typically to a city council or county commission, which will make a final determination. The next board is the Board of Adjustment. It's a much more specialized board. It hears a much narrower subset of cases. Typically, it will hear things like variances, historical preservation related issues, and sometimes it will hear special use permits, all of which are quasi-judicial, and we'll touch on that term later. But it's important to know that it's a little bit more of a specialized board and hears a much narrower subset of cases because of that. And then finally, we have the city council and county commission. Those are elected officials. They obviously deal with a wide swath of issues beyond land use regulation, but they will be the final decision makers for things like rezonings, special use permits, and the like. And so it's important to know that those elected officials do have a very, very big hand in determining land use regulation, in determining changes to the ordinance, and in determining specific cases of rezonings and permittings. Now we'll dive into kind of the category of cases or types of cases you may see. The first is a rezoning. And I think a lot of people are probably familiar with rezoning, which is just a request to change the parcel or parcel's zoning district. And if you're asking, what is a zoning district? That is outlined in the UDO and LDO. They set out numerous districts that are typically, categorized as single family, multifamily, office and institutional, commercial and industrial. And within each of those categories, you'll have multiple or several different districts that are based upon density or use type. And within each of those districts and within each of those specific categories, each of those permits certain uses and prohibits certain uses. Some that are permitted as right, some that are permitted but require a special use permit or adherence to special development standards. And then you'll have certain uses that are outright prohibited in those districts. And then each, as I stated, has distinct development standards and requirements. So that's why, kind of going back to the zoning map, it's important that you first figure out, what is a parcel zoned or what is a property zoned, because then you can take that information, go to the UDO and LDO and figure out, okay, what does this zoning district mean? What is permitted in that district? What's prohibited in that district? What are the buffering requirements? What are the setback requirements? What are the height requirements, and so on? And one of the important things here for rezoning in that last bullet is it is a legislative decision. It is one that, as long as they are adhering to the UDO and the LDO, the decision whether or not to rezone a property can be based on a number of factors. It can be based on community input, potential community impact, economic impact, and what have you. So there's a lot of discretion given to zoning commission, city council, and county commission for legislative decisions like rezoning. The next subset of cases are conditional rezonings, which are what I call a standard rezoning on steroids. So it's the same type of request, which is to change a parcel or parcels zoning district, but then it puts forward more strict or stringent conditions than what is set forth in the UDO. And so in pursuing a conditional rezoning, you can condition certain uses. And so you can say, in X district that I want to rezone to, these permitted uses, I will make them prohibited. Or you can increase the minimum setback or increase the required buffering, or you can condition access. You can condition the maximum height down. You can make the maximum height smaller than what it is. It allows you to kind of create a little bit of a new ordinance in the rezoning. You still have to comply with the UDO and the LDO. Those set forth the floor, but you can then put forward more stringent conditions. And this is an important type of rezoning, and it's one that for my commercial developer clients, absent them telling me that it is just not feasible from an economic standpoint, is something I often encourage them to pursue, especially if they're located nearby or adjacent to residential properties, because it is a way to put the developer's best foot forward. It's a way to give additional concessions to the community and to make it a little bit more stringent on the developer, and working with the community to make sure that the potential impacts of the development aren't felt by the community or by the adjacent residential. And so I mention that because, if the association comes into contact or has a potential issue with a adjacent development, I would encourage, and we'll get to this here shortly, I would strongly encourage the association to look to a potential conditional rezoning in approaching the developer with conditions and say, would you consider XYZ conditions as part of your application? And so I think that's an important piece that the association should remember, is that the association, the developer at the end of the day has to agree to those conditions, but the association needs to know that a conditional rezoning is absolutely part of the regime and is something that the association can bring to a developer and say, look, would you consider potential conditions? And it can be a good way for a developer and the community to bridge the gap or to come to some sort of agreement about how a development should look and be structured. The next type of case is a variance. Variances are handled by the Board of Adjustment. They are quasi-judicial, which we'll touch on in more detail in the special use permit part of it. But essentially quasi-judicial is a blend of legislative and judicial. It's kind of a hybrid of those two, where you do have kind of these legislative components. It's not as strict as a judicial proceeding, but you do put on evidence. Witnesses are sworn in. There is more structure than a typical rezoning or a conditional rezoning hearing. Variances, as the name says, are a request to vary from the regulations of the UD or LDO due to some type of undue burden and unfair hardship. And what I will tell you is that in the state of North Carolina, it is incredibly difficult to get a variance. It is not impossible. We've been successful in pursuing variances for clients, and there are certainly cases where a variance is justified. But I will tell you that it is an incredibly high standard. Specifically, it requires a showing of undue hardship. And that can be very difficult to meet because you can't create that hardship yourself. The property owner can't create the hardship. And not only that, the hardship has to be unique to the property. And typically what they're going to look for on that end is that there is some physical element, whether it be topography, the layout of the property, the sloping of the property, or something similar that impacts or potentially outright prohibits a developer or a property owner from strictly complying with the UDO. And so, as you can imagine, those instances are narrow. A variance is not a tool to use just because you want something to look a certain way or you believe that it should look a certain way. There really has to be some overarching circumstance, either with the property or with the development itself, that then necessitates equity coming in and saying, look, we need to vary from the strict regulations. But I counsel clients all the time that a variance should be really your last gasp here, and it is probably at best a lot of times a coin flip. And that to avoid a variance, performing due diligence on the front end can help save you a lot of heartburn, a lot of legal expense, a lot of time, because a lot of times clients will come and say, I want a variance, and it's something that they have self-created. It's something that could have been addressed at the due diligence stage on the front end, and now they're trying to seek relief that is likely to be unsuccessful. The next type of request is a special use permit. I touched on this a little bit earlier. Again, we're in that quasi-judicial mode, which is a blend of legislative and judicial, a little bit more formal than a legislative hearing. And what this is it's a specialized process for approval or consideration of certain developments or uses. And typically those are unique uses, they're high intensity uses, or they're uses that have the potential or the probability for significant impact to adjacent property owners and the nearby area. And because of that, a special use permit is required, and in so doing, it requires more certainty to be provided from the applicant and developer in terms of layout, development standards, appearance, parking, traffic, et cetera. It really puts a much higher burden on the applicant or developer, and the applicant must meet specific standards. As we touched on with the rezoning, the consideration there, the zoning commission or the city council can look at a whole host of factors, and there are no set factors that they're required to consider other than compliance with the UDO and LDO. In a special use permit, each municipality will have specific standards which are set forth in by state law, and those are jurisdictions may vary the verbiage or the wording of them, but consistently throughout, an applicant must show that the proposed use is in harmony with the surrounding area, that the proposed use will not have a negative impact on health and safety and the general welfare of the surrounding area, that development will not negatively impact adjoining properties and specifically adjoining property values. And finally, the applicant must show that they have complied with all of the municipal regulations set forth in the UDO and LDO. So it is certainly a much higher burden, and it's a tool that jurisdictions and municipalities use to have tighter and greater control over those high intensity uses or high impact types of uses. So now that we've done the rundown of the different types of cases, we'll take a look at those two buckets of kind of problems that we highlighted at the beginning. The first being those internal problems, which I mentioned may not really be an association issue, but rather a member issue. And it may not be something the association deals with as often as an external problem brought about by an adjacent or nearby development. And really what these problems look at are things like short-term rentals, which honestly, we could probably have an entire presentation on that. There's certainly a lot of literature out there concerning short-term rentals in North Carolina. That is a constantly evolving area of land use regulation, both within municipalities, at the state legislature, and in the courts. And so it is something that is constantly evolving, and something we can certainly talk offline about, but it is something that the association needs to be aware of, because in the coming months and years, there will certainly be more clarity, I believe, about short-term rental regulations. The other types of problems or other types of issues you run into are occupancy restrictions, leash laws, and then those development standards. I think, as I said, the development standards are probably the most common internal problem an association or an association's members will face, because those types of standards go to setback restrictions, buffering requirements, height requirements, and those types of things. Then we turn to the external problems, which are more common for the association at large. And again, as I've said, those concern development around or nearby an association. And it's important for the association to determine how the association wants to address each of those potential developments or problems. And really, they're going to be site and development specific. So it's going to require an assessment of what is being proposed nearby or around the association. And then moving on from there, it's looking at how can the association or how can the association's members challenge a land use request. A lot of times we will get questions, or I will get questions about, Clint, a new development is coming nearby my property. How do I go about challenging that land use request? And really it begins at knowing when a new development is coming into your area. And it begins with, keeping your eyes peeled, keeping your ear to the ground for public notices, because public notice is required when a development application is submitted. If we'll go to the next slide, we lay that out, which is there should be both a posted sign at the property that details what the request is. Also, if you're within a certain distance, and it can kind of vary from jurisdiction to jurisdiction, it may be 300 feet, maybe 600 feet, maybe 800 feet. They're required to mail you, the municipality mail you a notice of a rezoning request or a special use permit request, whatever the application is. They're required to notify you via mail that a request has been submitted. I would also, again, going back to one of my primary points, encourage you to reach out to the planning department if you hear something, if there is gossip about a potential development, or if there is some information that is gathered that a development may be coming to the area right around the association. Having that planning department contact can be very, very important. Now, if it's, if the application has not been filed, they may not be able to tell you a lot. They may defer until an application is filed. But once an application is filed, they should be able to take you, or they should be able to tell you what is going on. And then you can also request the application materials at that time, because those are part of the public record. And then the third point there is to, once you've gathered that information, you kind of understood what's going on, is to perform due diligence on the proposed zoning. Understand what the current zoning district is, understanding what the requested zoning district is, figuring out what uses are permitted, what uses are prohibited, what the development standards are. And I say those as not being, per se association obligations. Those can be obviously directed to legal counsel, or can be performed kind of in concert with planning staff. But just having that information, or being able to gather that information, can best situate the association to challenge a potential development. It's important in looking at at how to challenge a land use request, to understand that the challenges will need to be really project specific. And that is, to the extent the association or an association's members want to challenge a land use request, making sure that those challenges are tailored to that specific project will increase the likelihood of success. The challenges where someone comes in and opposes it because they don't want something next to them, or they're just opposed to any and all development in the area. I'm not saying those can't be successful, but certainly those are significantly less successful than those that are tailored specifically to the project. So performing that due diligence on the front end, again, best positions a challenge to a land use request. Point 2 here goes back to our discussion on conditional rezoning, which is I would greatly encourage the association to assess what the impact to the association is going to be and what the impact of the development will be to the association. And you see those categories of traffic, lighting, odors, noise, sightlines, and property value, and assess which of those things are most important, or which of those concerns are most at issue with the potential development. And then I think it's in the association's best interest to look to see if proposing conditions to the developers to address those issues and to mitigate those concerns are feasible. And if they are, the association can use that conditional rezoning tool in its toolbox and put together some proposed conditions to then take to the developer to see if the developer is amenable to those conditions. And in doing so, I would also encourage the association, if it is faced with that and does put together those conditions, to really figure out which conditions are top priority, which are things that absolutely need to be included for the association and its members to back the proposed land use request, and which things are maybe important or desired, but not absolutely essential. And I think that in doing so, if an association thinks that conditional rezoning is possible and that conditions will help better address the issues of the development, that will put the association in a much better position. The next keys to kind of challenging a land use request here are community organization and involvement. I can't tell you the number of times having an organized community, having an organized association or neighborhood really has spurred developers to take aggressive actions on conditions, has made developers address potential deficiencies in their application, or that organization has really, to the extent a community or an association wants to outright oppose a request, that type of organization has a big sway on public officials. So to the extent the association or its members have concerns, getting organized, getting people involved, and getting that organization involvement off the ground fairly quickly, and using the association to the extent that the association is comfortable doing so as an organizing principle, can really put the association and its members on track to achieve either concessions from a conditional rezoning perspective, or to oppose the rezoning outright, or oppose the land use request outright. The second bullet honestly should probably be first on this slide, but I would always encourage communication with the developer, and communication with the developer really at the outset. A lot of times people will get in their corners, whether it be a developer or a neighborhood, and they'll kind of go to their corners and dig in on fighting it out, when there can be common ground achieved through conditional rezoning or a better understanding of what the land use request is. So I really encourage all of my clients, whether it be a developer or a community, to have conversations with one another. And so for the association, I think it's very important that once you learn about a proposed request and kind of get a better understanding of what that request is, to have a dialogue with the developer. And then finally, we have the public hearings, where the association or its members have the opportunity to develop a presentation to challenge the request. They can emphasize the impacts of the proposed development. But again, you need to base it as in the UDO, in the LDO, and in kind of, those interactions with the developer or the potential impacts of the specific development. It's important to tailor it to those specific impacts, to the law at hand. That's how the presentation is most likely to succeed. The next slide touches on land use regulation enforcement. So this is, after an approval occurs, I have clients who will say, Clint, how do we make sure that a developer is following the UDO or LDO? We're worried that they're not going to meet those obligations, whether it be stormwater regulation or setback requirements or buffering. If we think that there is an issue or a deficiency, how do we address that? And unfortunately, my answer a lot of times is the burden really does fall on those neighborhood members and those adjacent property owners, because enforcement is very inconsistent from municipality to municipality. And there's just not enough, there aren't enough staff members there and enforcement members there to kind of go project to project and perform these measurements and ensure total compliance. So the burden unfortunately falls on those adjacent property owners to speak up if there's a potential issue or if they think there's an issue, and inform the planning department, which again goes back to having a contact or having a comfortable a level of comfortability with the planning department, so that you can reach out to them if there is an issue that you think rises to the level of enforcement. What I will say is a lot of times the initial enforcement, if there is some violation, will be a warning. It could be a minor fine, depending on the type of violation. It could warrant pulling of a permit, whether it be a special use permit or a building permit or what have you. But a lot of times the initial step will be either a warning or a small fine. So it's just important to know that that there is that inconsistency with enforcement. That enforcement falls a lot of times on the neighborhood, and that the enforcement may not rise to pulling a permit until a warning or a fine has been issued. And so to kind of tie everything together, again, kind of the purpose of this presentation is to give you those fundamentals, those basics, so that you can spot issues, you can know where to go and find that information, and you can kind of set up a regime that will help you be put in the best position to address land use issues. But here are kind of the best practices. Again, familiarize yourself with your jurisdictions, UDO and LDO, which again begins with figuring out what jurisdiction you're in, and then going and locating the UDO and LDO. And then from there, you need to understand the subject property zoning. I would encourage you to understand the zoning in the surrounding area, so that you can see if you're an association that's located in a more mixed use area, where is their commercial, where is their office and institutional, where is their potential industrial uses, and understanding what potentially could come there or what potentially may be developed there in the future. Third, I would encourage you again strongly to have some type of relationship with your planning staff. It doesn't need to be one of constant contact, but you do need to develop some type of relationship with your planning staff, so that you can go to them with questions or issues as they come up. And by developing that relationship, you'll be comfortable going to them with those questions or those issues. And then finally, kind of keep your eyes open, your ear to the ground for information, gossip, publicly available information, posted notices, and mail about potential development that may be coming nearby an association. Because if you're able to gather that information early, you're able to perform due diligence early, you're able to organize early, and you're better able to develop conditions, oppose, or just address that development, and the association can put its best foot forward. And so those are the best practices. Again, I hope everybody got a lot of information about the basics here, the fundamentals here, that that can then be helpful to the association. And I'm obviously happy to answer any questions here or also offline.
Great, thank you so much, Clint. And we actually do have a few questions, so I'll just start running through those since we do have some time left in the session. So the first one is, since the HOA is often viewed as an entity that has little to no influence on the municipality, do you recommend that as voters and taxpayers, that individual property owners also contact the municipality with their inquiries and requests, even if it is only the homeowner board members?
Yes, I do. I think the more voices that the planning staff or elected officials are hearing from with questions, concerns, comments about a potential development, the more likely the staff and the elected officials are to bring those questions to the developer. They're more likely to closely scrutinize those particular issues. And so I do believe in kind of the more voices you can get, the better. I will kind of couch that by saying, I think the association can serve as a good organizing principle. And I also think that if appropriate, and obviously if it calls for it, having somebody reach out on behalf of the association can also be a huge force, because the association, is an organizing principle here, addresses issues and concerns for potentially a lot of different members of the community. So I think having that kind of dual-pronged approach can be very, very successful in bringing issues and concerns to both staff and elected officials.
Great. And we had another question come in that I think dovetails with that first one, which is, does this apply to declarant controlled HOAs, as often those boards are not significant supporters or serve as a representative to the municipality of the community's opinions related to adjacent developments?
Yeah, and I think, I would kind of co-sign what I just said. But my hope in those situations would be, even if those boards are not, really going to serve as that organizing principle or outreach, that they'll at least make those, make the property owners within the association aware of what's coming. Hopefully the property owners are receiving those notices themselves, but sometimes in larger associations, some of those lots may fall outside the required mailing radius. So the hope is that you would have those boards or have the declarant or what have you at least provide that information so that the property owners can, if they want to, on their own volition, reach out to staff or reach out to elected officials with those concerns and questions.
And then we have one more question before we wrap up, and it's a two-parter. So I'll read the first one, and then dependent on your answer, there's a follow-up. So that question is, what are the options if the association is managed by a property management company that will also or is managing the neighboring community under development? Is that a conflict of interest?
Yeah, I think that raises an interesting point that I will admittedly say I've not seen. To me, I think that does raise a potential conflict of interest in terms of kind of actively campaigning against or opposing a development. I think it's likely appropriate if the request has been made or if there is publicly available information for that information to be made available to members of the association. But I would counsel that you should be very careful in doing that. I would recommend that, based upon the situation, that you reach out to legal counsel to get a legal opinion based upon the facts and circumstances. And I do think that it potentially does raise a conflict of interest issue. And I think, again, seeking legal counsel on that specific issue is best.
Great. Well, thank you very much to Clint, and thank you for all of you who attended today. Appreciate you joining us and also working through those few PowerPoint issues we had to begin with. So for those in attendance following the webinar, you will be sent an email with a list of articles related to the issues discussed today, as well as a recording of the session and a link to sign up for our community association alerts. We appreciate you taking your time to join us. We hope you're able to take some of the information you learned and apply it to your own organization. Thank you again, and that concludes today's webinar.